Good morning, friends. I am again before you with folded hands to discuss one of the important question which was in Advocate on Court examination 2019. The question is, what is curative petition? On what ground can a curative petition be filed? What is the procedure required to be followed for filing a curative petition? So, friends, these are the questions. It was question which carries 10 marks. But sometimes this alone question comes which carries 20 marks alone. So I am discussing with the view that it will be of 20 marks. So be settled. I am going to explain the fundamentals behind curative petition and what is the procedure to file that. So, friends, firstly, what is curative petition? Curative petition is an ultimate tool which was devised by the Honorable Supreme Court itself for reconsideration of its final judgment order passed even after dismissal of review petition. Such remedy is based upon the principle ex debitio justitia, where the Supreme Court reconsiders its final judgment order in exercise of its inherent and supervisory jurisdiction, being the apex court of the country, for preventing the abuse of process and to cure a miscarriage of justice. Honorable Supreme Court exercises such powers under Article 129, being the court of record, and also from Article 142 of the Constitution for doing complete justice. This concept of curative petition was evolved from the idea that is put forth by Latin maximum actus curae nominum gravit, which say that act of the court shall prejudice no one. Now coming to origin of curative petition. Friends, this formal concept of curative petition was evolved in the case of Rupa Ashok Hura versus Ashok Hura, that is 2002, volume 4, SCC at page 388. Such power was discussed in the name of ex debitio justitia in the case of A.R. Amtule versus R.S. Naik, 1988, volume 2, SCC at page 602. And second case was Naresh Shridhar Mirjakar versus State of Maharashtra, 1966, volume 3, SCR at page 744, for preventing the abuse of process of court and to cure gross miscarriage of justice. Friends, when the case of Rupa Ashok came before the Honorable Supreme Court for reconsideration, the questions that were raised in this petition were whether an aggrieved person is entitled to any relief against a final judgment or order of this court after dismissal of review petition, either under Article 32 of the Constitution or otherwise. This was the question in Rupa Shokpura. The Honorable Court, I mean to say Supreme Court, held in its para 14 that on the analysis of ratio laid down in the above mentioned cases, means the case of R.S. Naik and Naresh Siddhar, we reaffirm our considered view that final judgment order passed by this court cannot be assailed in an application under Article 32 of the Constitution of India by an aggrieved person, whether he was party in the case or not. So they said no to 32. And in para 15, it said that in fairness to the learned counsel for the parties, we record that all of them at the close of hearing of these cases considered that the jurisdiction of this court under Article 32 of the Constitution cannot be invoked to challenge the validity of final judgment order passed by this court after exhausting the remedy of review under Article 137 of the Constitution as well as under Supreme Court rules. Further, in para 48 of the judgment, this court reconsidered its earlier judgment under Article 129 and 142, which confer very wide power on this court to do complete justice between the parties. So, the scope of power of this court under Article 129 as a court of record and power under Article 142 of the Constitution was considered, whether these powers can give relief. So the result of above discussion is that this court, to prevent abuse of its process and to cure a gross miscarriage of justice, may reconsider its judgment in exercise of its inherent power. So they said that we can give relief under Article 129 and 142 of the Supreme Court of India. So, friend, the next step by to specify the requirement to entertain such a curative petition under the inherent power so that the Constitution Court is not unnecessarily flooded with fictitious curative petitions. So, when a very strong reason exists, the court should not entertain an application seeking reconsideration of this court, which has become final, or dismissal of the review petition. It said that except when a very strong reason exists, it shall admit curative petitions. It further said that petitioner is entitled to relief ex debitio justitia if he establishes, first one, I'm discussing about grounds. Violation of principles of natural justice, in that he was not party to the list, but the judgment adversely affected his interests, or if he was party to the list, he was not served with the notice of the proceeding, and matter proceeded as if he had notice. Second ground, where in the proceeding a learned judge failed to disclose his connection with the subject matter, or the parties, giving scope for an apprehension of bias and judgment adversely affected the petitioner. The petitioner, in its para 52 of the Rupa Shokura, the court said that the petitioner in the curative petition shall ever specifically that the grounds mentioned therein had been taken in the review petition, and that it was dismissed by circulation. The curative petition shall contain a certificate by the senior advocate with regard to the fulfillment of the above requirements. In its para 53, it said that we are of the view that since the matter leads to re-examination of final judgment of this court, though on a limited ground, the curative petition has to be first circulated to the bench of three senior-most judges and the judges who pass the judgment complained of, if they are available. It is only when the majority of the learned judges of this bench concluded that the matter needs hearing, then it should be listed before the same bench as far as possible, which may pass appropriate orders. It shall be open to the bench at any stage of consideration of the curative petition to ask a senior counsel to assist as an amicus curiae in the event of bench holding at any stage that the petition is without any merit and vexatious, it may impose exemplary costs on the petitioner. So, friends, let us further brief about grounds. Order 48 of the Supreme Court Rules 2013 deals with practice and procedure of curative petition. But the grounds are governed by the Rupa Ashok Khura versus Ashok Khura. Honorable Supreme Court had laid down the grounds for the filing of curative petition. First one is violation of principles of natural justice, that he was not a party to the list, but the judgment adversely affected his interest, or if he was party to the list, he was not served with the notice of the proceeding, and the matter proceeded as if he had notice. Second is where in the proceedings a learned judge failed to disclose his connection with the subject matter or the parties, giving scope for an apprehension of bias and judgment adversely affected the petitioners. In Yaqub Abdul Razak Menon versus State of Maharashtra, this case is of 2015, volume 8, scale 1 to 5. The Supreme Court has reiterated that curative petition is maintainable only when grounds taken are in terms of the principles laid down in Rupa Ashok Khura versus Ashok Khura. Now, let us dive further into practice as procedure. The question can be asked from any point of view. So I am going to prepare from all angles so that you may get marks after going through this video. Order 48 of the Supreme Court Rules 2013 prescribes the practice and procedure to be followed. Firstly, it says curative petition shall be governed by the judgment of the court dated 10th April 2002, delivered in the case of Rupa Ashokura versus Ashokura and others. Friends, the writ petition was civil, number was 509 of 1997. Second rule is the petitioner in the curative petition shall ever specifically that the grounds mentioned therein had been taken in the review petition and that it was dismissed by circulation. The curative petition shall be accompanied by a certificate of the senior advocate that the petition meets the requirement of stated in the above case. A curative petition shall be accompanied by the certificate of the advocate on record to the effect that it is the first curative petition in the impugned order. The curative petition shall be filed within reasonable time from the date of judgment or order passed in the review petition. Sometimes, friends, there is short question, what is the time limit to file review petition? So, your answer should be that curative petition shall be filed within reasonable time from the date of judgment or order passed in the review petition. The curative petition shall be first circulated to the bench of three senior-most judges and the judges who pass the judgment complained of, if they are available. Unless otherwise ordered by the court, a curative petition shall be disposed of by circulation without any oral arguments. But the petitioner may supplement his petition by additional written arguments. If the bench before which a curative petition was circulated concludes by majority that the matter needs hearing, then it shall be listed before the same bench as far as possible. If the court at any stage come to the conclusion that the petition is without any merit and vexatious, it may impose exemplary costs on the petition. Thus, friends, the curative petition has proved to be a substantial device to cure injustice manifested in the final judgment order even after dismissal of review petition and has helped in helping the correct rule of law in the country. So, friends, from all angles, I have covered the curative petition. Go through this petition again and again so that if this question comes in the examination, you may remember Advocate Ashok Arora, who helped you a lot by spending his valuable energy and time to prepare this video. That's all. God bless you all. Thank you.